Good afternoon, my name is Eugene. The topic for today is the current COVID-19 context at the Supreme Court of Canada. That's why I'm wearing this special mask. The COVID-19 context at the Supreme Court of Canada, does it change how you litigate at the court? What's the potential impact for litigants going there? You may have a case going to the Supreme Court of Canada. You may be considering a case that is going to the Supreme Court of Canada from one of your clients. You may have a Court of Appeal decision that you're waiting for. The bottom line is that our firm, the Supreme Advocacy LLP in Ottawa, we're just south of the Supreme Court of Canada building. We're fully open, fully operational. I'm working here at the office alone. All other lawyers and staff are remote. The Supreme Court of Canada are fully operational, except that the building is closed to visitors. So we thought about what would be the top 5 frequently asked questions that our clients are asking us at the present time about COVID-19 and litigating at the Supreme Court of Canada. So here they are. Here's 5 questions and 5 answers. Question number 1, is the Supreme Court of Canada open? The answer is yes. The Supreme Court of Canada is open. They are fully operational. They are open for all case matters, leaves to appeal, appeals, judgments, notices, filing, etc. The building itself is closed to visitors and the public. The registry is open, and the Supreme Court of Canada itself continues to issue leave judgments, appeal judgments, and there is much back and forward between the registry and your Supreme Court of Canada agent. That is number 1. Number 2, how does the COVID-19 context affect deadlines that I have at the Supreme Court of Canada? There are 2 sets of deadlines at the court. There is the statutory deadlines, and that cannot be changed. There is also the regulatory deadlines, and that is in the Supreme Court rules, which can be waived or extended by the court. The statutory deadlines remain in force, and those statutory deadlines are primarily for leaves to appeal and also for notices of appeal. The regulatory deadlines pursuant to the Supreme Court rules, those have been temporarily delayed, and this impacts responses, replies at the leave stage. It also impacts documents, motions, and other filings, including motions for intervention. Those key changes took effect as of March 25, 2020. 2 key deadlines are statutory deadlines that do not change, cannot be changed, and that is the leave to appeal deadline to file the leave to appeal, and also the notice of appeal. And that notice of appeal can be for as of rights as well as regular appeals. Some deadlines are suspended during the month of July and for the period of December 23 of 1 year through to January 3 of the next year, but the time limits for leaves to appeal and notices of appeal are not suspended during the Christmas recess. Number 3, what does this mean for you and your client? Despite the temporary delay for some deadlines, the court has said that they encourage everyone to file on or before the deadline. And if you do not intend to serve a response or a reply, though that is of course rare, the court wants you to notify the registry and of course opposing counsel. Number 4, how do I serve, or how does your Ottawa Supreme Court agent serve and file documents during the COVID-19 context if the building itself is closed to members of the public during the so-called quarantine period? Well, court documents are to be served and filed by email at this time, whether originating or otherwise. Parties are not to file paper copies at the present time, but will be required to do so in the future when so advised by the court. Number 5. Number 5 is, do I need to inform the court about the late filing of documents? Where circumstances such as COVID-19 prevent the timely filing of, for example, service and filing of leave to appeal, the court will not require a formal motion to extend time as it did in the past. It is sufficient at the present time to request an extension in Part 5 of the Memorandum of Argument itself. However, is that a good idea? Let me speak plainly. The answer is no. It's not a good idea, particularly for an applicant. If you're an applicant and you're taking the position that your case is extremely important, you're taking the position that your case is of national importance, do you want to take the chance that a judge or a panel of the judges of the Supreme Court may ask themselves, if this case is so important, of national importance, why are they late? COVID-19 notwithstanding. So, if you do request an extension at this time, would it be granted? Almost certainly, yes. Is almost certainly the best standard? I suggest not. And my suggestion is that whilst it may be granted oftentimes these days, oftentimes is not enough. There is a risk. The Supreme Court of Canada does reject some applications to extend time for what the court considers good reasons. And from a strategic perspective, what if the leave to appeal is not granted? What position are you in then? From a strategic perspective and a tactical perspective, it's important that your leave to appeal be in on time and be filed on or before the deadline. It's just safer that way. And the question as to why you may be late, COVID notwithstanding, is simply not there. In conclusion, drop us an email at our firm. You can drop an email directly to me. I will respond immediately and directly myself, emeehan@supremeadvocacy.ca. If you need anything done here, let me know. I am working alone at the office by myself. Everybody else is remote. So I'm becoming a strong expert in photocopying. Scanning is my strong point at the present time. So answering phones, I can do all of that. You need any help on anything at all, call us, let us know. All the best. Merci beaucoup.